It's called sufficient charge.
Okay. Good morning. Good morning, everyone. Today we have Ms. Riya Mani, who is an advocate based in Delhi, who had practices in Supreme Court, High Court, and all trial courts in Delhi, basically. And today we'll be discussing one core area of criminal law, which, and it's a very common question that everyone has, is on bails and anticipatory bail. Let's start with understanding. First of all, I would like to welcome Shreya for today's webinar.
Thank
And Shreya, I would like you to introduce yourself also for the audience. So before we begin with.
Thank you for that introduction, Amartya. So just so you all know that I graduated from GNLU Law School about 5 years ago. It's been a long time now. And thereafter, I went to work with Amarchand Mangaldas briefly. I worked in a corporate law firm and did a fair bit of commercial litigation, actually, which had nothing to do with criminal law. But I think my staunch love towards criminal law brought me back to litigation. I started litigating with my father, who's also a lawyer. Thereafter, I actually ended up majoring in international criminal law when I went out for my studies to Oxford. I did my LLM from there. After which I was lucky enough to get onto a stint with the International Criminal Tribunals at The Hague. So I did a fair bit of international criminal law there, saw criminal law from a very different perspective there. Then I came back to India because, again, it was litigation which brought me back home. And it's been about now a year ever since that I've been working in the law courts in Delhi. I do a fair bit of Supreme Court, High Court, and a lot of trial work also. In fact, what's interesting is that because you've called me to talk about criminal law, I'm going to talk about more of my trial law practice because I think that's where you have more of bails and anticipatory bails to that extent. So I'm going to start with that and then take you on to probably what I do in High Court and Supreme Court as far as bails and anticipatory bails are concerned. So that's that, yes.
Yeah. To begin with, let's understand what is a bail and what is the difference between bail and an anticipatory bail, or like what it is.
Okay, so I think I'm going to start with the very basics because, when I was interacting with a lot of interns and juniors, I realized that a lot of people don't understand where do you go to apply bail? What is bail, like you're asking? What is anticipatory bail? So before going and jumping into that, I'd like to tell you that there is a hierarchy of courts. So when you talk about criminal courts, the first base level that you have is a judicial magistrate first class. After which you have the Sessions Court, after which you have the High Court, and then of course you have the Supreme Court. So depending upon the gravity of the offense and the severity of the punishment, what you can do is move a bail application to either of these fora. So we're going to discuss that later when you ask me specific questions, but I just want you all to keep in mind sort of this hierarchy when we talk about bails and anticipatory bails in general. So the whole purpose of bail is to essentially ensure a person's presence in court. When you have trials and investigations that are going on, of course, there's one side of the lobby which says that you have human right violations and everybody's individual liberty is very important. But the whole purpose of bail in general, from a very layman's perspective, is to ensure the person, the accused's presence in court. So how do you ensure that? You have a written agreement between that accused and the court saying that whenever the accused's presence is required in court, he or she will come and probably help and cooperate with the investigation. So that is essentially, in a very layman language, what bail means to just understand. So it's a contract or a written agreement to that extent. Secondly, there are two kinds of, so this is something, again, which you should keep in mind before I talk about bails and anticipatory bails, because this is terminology that I'm going to use probably when you ask me questions ahead. So there are two things. One is a police custody and the other is a judicial custody. So a police custody is essentially a remand or a police remand wherein you have investigation that is actively done by the police. So what the police does is that it catches the accused, it arrests the accused, and then that person is sent to PC. So it's, as an abbreviation, we call it PC. And then that person actually is investigated by the police. Questions are asked. He's taken to the site where the spot of incident occurred, etc. After this whole period of investigation is over, then the police submits, the investigating officer submits a status report in court saying that now I don't want any more days of PC. So the accused can be sent to JC. JC is what they call judicial custody. So once the person goes from PC to JC, when he's in PC, he's under the police officer's control to that extent. But in JC, he's under the judge's control, the judicial authority's control. And this is all that is happening in the trial court. So this is all in the magistrate or sessions court that's happening. We haven't reached the high court as yet. So when the person is sent to JC, that's when he can move a bail application. So this is a very important difference which a lot of lawyers, junior lawyers, and we don't study all this in CRPC, that you can only file a bail application once the accused is sent from PC to JC. If the accused is in PC, your bail application is premature. You cannot file a bail application. Why? Because even the Supreme Court cannot interfere with the investigating authority's work. And the police is the investigating authority. So the second most important thing to remember is that you can only move a bail when the person is in judicial custody or JC. This is all that I've talked about is regular bail. Now, the other mutually exclusive route is called anticipatory bails, like you asked me. What happens is that when a person is fearing arrest or apprehending arrest, he or she may actually move a bail application to the court. And this is to the court. It has nothing to do with the police. Directly to the court, saying that I am apprehending arrest and I have certain very important things to tell the court, because of which I may not be arrested and I should not be arrested. So he makes this application to the court. And what happens is that that is essentially called an anticipatory bail application. Now, what he does is that he can either move the sessions court. Sorry, Amartya, are you there on the line? Chitna asked them. I think we seem to have forgotten the line somewhere. It seems to be hung. I think we seem to have lost him. We seem to have lost him, but or he's just enough. Yeah. Did we lose you, Amartya? Are you there?
Yeah, I'm there.
Okay. So I was just telling everybody. It's okay. Can you see me now?
Yeah, sorry.
Okay, fair enough. So I'm just going to continue. So what happens is that I was just telling everybody about what you do when you have to move an anticipatory bail application. So what you do is that you can either move the sessions directly or the high court. So you cannot go to a magistrate court when you're filing an anticipatory bail application. You have to move directly to the sessions court. So again, remember the hierarchy of courts in your head, sort of a thing. So if you're moving a regular bail, you will go to the magistrate court first, depending upon the gravity of the offense. But if you're moving an anticipatory bail, you directly go to sessions court first. If the session court rejects your bail, then you go to high court. So this is the basic, sort of very basic difference between regular bails and anticipatory bails. When you're fearing arrest, you move an anticipatory bail under section 438 of the CRPC. When you're actually in JC, when you're in custody of the police, you're in jail, then you move a regular bail application. So that's 437. So this is a very basic difference between the two. Go ahead, Amrita.
Yeah. So just to seek a clarification here,
Yes.
like in the time of a police custody, which is basically the time of investigation, the bail will be an anticipatory bail, or you cannot even have a bail at that point of time.
No. Once the investigation has started, what the police does is, depending on whether the police has arrested the accused or not, you select which bail to move. So if the police has already arrested you, then you will move a regular bail. If you're in JC, if you're in PC, then you can't move a bail. Every time you're in PC, you have to appear in court. So what the judge does is, I'll explain for all those who may not understand the concept. So what happens is that once the investigation has started, I presume that there has been an FIR lodged against you, right? That is when the investigation starts. So once an FIR has been lodged against you, the police investigating officer will contact you and tell you and try to look for you if it's a non-bailable offense. Which brings me back again to explaining, and you can put this question to me later on, what is the difference between a bailable and a non-bailable offense? So if it's a non-bailable offense, then the police has no power to grant you bail. So what the police is going to do essentially is that the police is going to look for the accused. It's going to try and arrest the accused. In this process of chase, what's going to happen is that the accused has a right to move an anticipatory bail in a non-bailable offense. So that is when he is going to approach the Court of Sessions or the High Court. So that is that. But on the other hand, when you talk of regular bails, if the accused has already been arrested and the investigation is going on and he's in police custody, he needs to wait until he's sent to judicial custody to move a regular bail application. So that's the difference between the two. I hope that's clear now.
Yeah. So in that connection, next thing we should discuss is like, what is the bail, what is the bailable offense and what is the non-bailable offense?
Yes, that's a very, very good question. So what happens is when you look at section 2A of the CRPC, and I'm just going to take you through that section. So it says that the bailable offense means any offense which is shown as bailable in the first schedule or which is made bailable by any other law for the time being in force. So this is a very bare reading of section 2A of CRPC, which says that it doesn't define what a bailable or a non-bailable offense is. What it does is that when you take the CRPC and you move to the last few pages, you have a schedule. So when you run through that schedule, in that list, you can see whether the offense is bailable or it's non-bailable. You can also see whether the offense is compoundable or non-compoundable. You can also see whether the offense is triable by a judicial magistrate first class or a sessions. So you have this schedule which is very handy. So when you look at that schedule, it tells you what is bailable and what is not bailable. So you have to look at that schedule to understand. But from a very layman perspective, as a lawyer who practices criminal law, I can tell you that when you have a 3-year punishment cap, below 3 years are usually bailable offenses. At a very generic level, below 3 years punishment, imprisonment in jail. But if you have some offense which attracts a punishment or an imprisonment of over 3 years, usually that offense is non-bailable in nature, as a very generic way of categorizing both. But this is not the exact definition, let me warn you. So what happens is that when you talk of bailable offenses, then the police officer has right to grant you bail, and your bail becomes a matter of right also of that matter. For that, I mean that if the accused, for instance, has been caught bribing, and so this is very strange in Indian law, and I was discussing with somebody the other day, but bribing an election official is actually a bailable offense in India. So when that happens, then the accused can actually be given police bail. Police bail is when the police officer can give you bail. So in a bailable offense, you needn't move an anticipatory bail or anything. You just go to the police station if the police wala calls you, and you just give your surety and whatever documents are required, go with a guarantor and just go and do that. And the police wala has full authority to give you bail in the police station. And a lot of people don't understand that. You don't need to pay money or bribe him or, give him goose to actually get bail. Bail is your matter of right at that moment. On the other hand, if your offense is a non-bailable one, so when you check that schedule at the end of the CRPC and you do not find your offense as being bailable but rather being non-bailable, then what you do is that you have to move a bail application or an anticipatory bail application. So first thing you should do is, the moment there is a particular charge, section charged against you allegedly in the FIR, check whether the section is bailable or non-bailable. That's the first thing every accused, even if he's wrongly been accused of doing something, should check before he actually does anything. And whenever it's a non-bailable offense, then the police has no authority to grant you bail. So then again, there's no need to pay any money to them. Only the court can grant you bail. You have to directly apply to the court for grant of anticipatory bail or bail later on if you're arrested, in the event that you are. Yeah, Amrita, go ahead.
There is another interrelated concept that is there is, what is an interim bail? Like, is there what does it actually mean?
Okay, that's a very, very good question. And this is a new fashion in criminal courts that have now developed. And I'm glad that when these questions were sent out, I think these were very, very pertinent questions, especially contemporaneously if we see. So now new fashion has developed in criminal courts. What the High Court or the Court of Sessions does is, it grants you an interim relief. That is basically what an interim bail draws from the word interim. So the interim of the interim bail means interim relief. So what happens essentially is this, and this is categoric to anticipatory bail applications. It has nothing to do with regular bails. So that's at the outset, let me just clarify that when you talk of anticipatory bails, you talk of interim bails. You don't have a concept of interim bail in a regular bail. So what happens is this, that you file an anticipatory bail application. From a practical perspective, first I'll tell you and then I'll tell you how theoretically it works. So from a practical perspective, you move an anticipatory bail application, and mind you, you can only move that before the sessions. If it's rejected from the sessions, you go to the High Court. So you move an anticipatory bail and the court thinks that there's actually some merit in what you are trying to say compared to what the FIR says. So what the court does is that it grants you an interim relief. And the interim relief can be in the nature of saying, for instance, that no coercive action be taken against the accused. And this word, no coercive action, means that no arrest. So what an interim bail does is that it essentially gives you a directive to the police to not arrest you. Okay, so it is not the bail in itself. Anticipatory bail and interim bail is not bail in itself. It is actually a directive given to the investigating authorities or the police authorities that in the event that the accused is arrested, he be not arrested. Or if he is arrested, he be immediately be released on bail, to that extent. So depending on the wording of the interim bail. So these are interim reliefs which are given to accused persons, that until the next date of hearing, no coercive action or no immediate arrest may be done, etc., etc. And like I said, this is only for anticipatory bails. It's not for regular bails.